Hello, everybody. Today we are going to be looking at the case of Tom Girardi, his law firm, Girardi Keese, and the complaint brought by the bankruptcy trustee for Girardi Keese against Mr. Girardi's wife, Erika Jayne, who I understand is one of the Real Housewives of, I'm guessing, Orange County. And you can tell me if I'm wrong in the comments, as I'm sure some of you will. So this specific complaint is brought by the trustee, as I said, against Erika Girardi, and I'm not going to get into the substance of it. I'm just going to show the part that is relevant for purposes of this video, which is highlighted here. You can see plaintiff Alyssa Miller is the trustee of the bankruptcy estate created in the Chapter 7 bankruptcy case styled In Re Girardi Keese. So she's the trustee for the law firm only, not for Tom Girardi personally. Paragraph 3, Girardi Keese, the debtor, is the debtor in the bankruptcy case, and this case was initiated by the filing of an involuntary petition under Chapter 7 of Title 11 of the United States Code. Title 11 is the bankruptcy code. So the only thing you really need to remember for now is the fact that it is Girardi Keese, the law firm, that is in bankruptcy in this case, and it is the law firm that is suing Ms. Jayne. A bankruptcy trustee steps into the shoes. That's the phrase we use. The bankruptcy trustee steps into the shoes of the debtor. So the trustee is acting as if she were the law firm. Now, this is where it's going to get dry for a little bit before I get to the good bits, but it is what it is. This is, as you can see, Section 109 of the Bankruptcy Code. That's Title 11, United States Code, annotated Section 109. Who may be a debtor? Notwithstanding any other provision of the section, only a person, yada, yada, yada. B, a person may be a debtor under Chapter 7 of this title, only if such person. We don't need to get into the definitions, just notice that it's specifically a person. A person is allowed to be in bankruptcy. So, what is a person? Fortunately, the Bankruptcy Code has an extensive definition section. This is the definition of person. The term person includes individual, partnership, and corporation, and then there's some other technical stuff. It doesn't really apply here. So you'll notice there's individual, that just means a human being, a partnership, which is two or more people, and corporation, that doesn't just mean corporation, that also means LLC, limited partnerships, professional corporations, a million other forms of business entities, typically registered with the state in which they're incorporated or organized. But it does not include sole proprietorships. And a sole proprietorship is just a person that is operating a business, and it's not any of these other things. It's not a partnership. It's not a corporation. It's just like somebody running little Timmy that's running a lemonade stand. That's, unless he's an LLC, that is going to be a sole proprietorship. It's just a person that's selling stuff. So that is the statute, and I'll turn to a case that I prepared here in Re Christenberry. And in this case, there was a sole proprietor, Christenberry, and she had a business, and she tried to file for bankruptcy as the business. You'll see here it is called Little Pigeon Roost. That was the business. And what the court held is that because Christenberry filed as Little Pigeon Roost, and Little Pigeon Roost was a sole proprietorship, it is as if Christenberry herself filed for bankruptcy. And I'll scroll down to the most relevant bit here. Moreover, bankruptcy law is clear with respect to whether a sole proprietorship can file for bankruptcy without its proprietor also doing so. Here is quoting from a Ninth Circuit case, and Ninth Circuit BAP or Bankruptcy Appellate Panel, and the Girardi case is within the Ninth Circuit. It's in California, so in re KRSM would be binding authority. A sole proprietorship is not a person for purposes of the Bankruptcy Code because it is neither an individual, nor a partnership, nor a corporation. 11 U.S.C. 101, that's what we just looked at. Since it is not a person, a sole proprietorship is ineligible to be a debtor in bankruptcy. Now, you may have inferred where I'm going with this. Critically, Girardi Keese was a sole proprietorship. This right here I'm not going to get into this. This is just formatted incorrectly, but we don't need to worry about that. This is what is called a SOFA, or a Statement of Financial Affairs. Usually just called schedules or SOFA. And what we will see, I kind of previewed it for you a second ago, is this section right here. Now, this was filed by the bankruptcy trustee. You can see here August of 2021. List the debtors, officers, directors, managing members, general partners, members in control, controlling shareholders, or other people in control of the debtor at the time of the filing of this case. And you'll see here we have Robert Keese, who retired in 2010, is listed as a general partner. You'll also see that the percent of his interest, if any, is marked as unknown, which is funny because just below that, we have Tom Girardi, who owns 100% interest in the law firm. Now, if one person owns 100%, this number is actually known. It's 0%. That's just the way percentages work. You see, there's 100%, that's like the whole thing. So, you wouldn't make this. I'm just, talking to the other people who aren't as smart as you. So that is the issue. Girardi Keese is a sole proprietorship, and it is in the trustee's own filings acknowledging that 100% owned by Girardi is a sole proprietorship. And the next thing I'm going to show you is one document. This one right here, it was submitted by this law firm here. Oh, I'm sorry, I don't have that. Abir, Cohen, Trezon, and Salo. They're still litigating this case. They're another defendant in a different adversary proceeding. They're in the same position as Erika Jayne. And you'll see here that they have a contract with Girardi Keese that acknowledges that Girardi Keese is a sole proprietorship and that Tom Girardi is the owner in principle. So both a defendant is saying that it is a sole proprietorship, and the trustee herself didn't explicitly say that it's a sole proprietorship, but she did say that is 100% owned by Tom Girardi, which is exactly the same thing, unless you can show that it's a limited partnership or some other kind of official entity, and they can't do that. They've tried, but they just haven't been able to. And more recently, the trustee has been trying to defend against the assertion that Girardi Keese was a sole proprietorship. And I'm going to show you the documents that she's used. This was actually a few years ago, but these are the documents that she used to try to show that Girardi Keese was a partnership. So here, this is from 2018. This is a tax return. You'll see it's a partnership tax return. It was filled out. It wasn't signed, which is a problem, but it is a tax return asserting that it is a partnership. Again, this was in 2018, so this was at least 2 years before the commencement of the bankruptcy case. So even if it's real, and I assume it is real, but it's not signed. Even if it was completely accurate, it wouldn't be that useful. And again, you need to remember that this is a case of financial fraud. So a document saying that, hey, we're a partnership, may not be the best evidence because their whole thing is, financial crime. I think you see where I'm going with this, but a financial document in a financial fraud case by the financial fraudsters is not going to be as convincing as it would be in a different context. So here we go. This is a loan date of 2018, maturity of 2019. I assume this was signed, let me see, sometime 2018, I guess. It says partnership, Tom Girardi, general partner. General partner, Tom Girardi is the only signer. So there's no evidence that there is another partner, which is really the issue here. Number 5, you see this is from 2011. So not that useful. The trustee needs to show that it was a partner as of the time of filing. Tom Girardi, senior managing partner. That is kind of a law firm term more than a partnership term. 2010. Chris Kamen, who's the CFO, he is in prison right now, but he's not listed as a partner. And the only partner who is signing is Tom Girardi. And again, this suggests that it certainly doesn't suggest that Girardi Keese was a partnership. And again, this is 2011, not that useful. And again, this is a financial crime case. So fraud in a loan document is not going to be the most convincing document or evidence in the world. Tom Girardi, James O'Callahan. James O'Callahan died in 2019. So this is just not relevant at all because we know that James O'Callahan was not a partner at the time the case was filed. David Lira. This is probably the most convincing. It is an assertion by David Lira that he was a partner. Again, though, this is in 2012. It is almost a decade before the filing. Not helpful, not relevant. So I don't know what value we're supposed to be taking from this. You have Chris Kamen, the CFO, not a partner. We have Annie Wilson, office manager, not a partner. Chris Kamen, CFO, again, not relevant, and it's from 2014, as you see. Partnership, Chris Kamen, again. This is a client trust account. James O'Callahan was dead for years at the time of the filing. O'Callahan again. Here we have a partnership resolution of authority. O'Callahan, who has passed away, and Amy Solomon and David Lira. And again, this is from 2014. It's from 7 years roughly before the filing. I don't know what I'm supposed to be taking away from this. This does not suggest that there was a partnership in 2021. Exhibit 6, partnership agreement for brokerage accounts. And again, I just want to take a step back here. This is what the trustee has. It's financial documents kind of maybe suggesting that there was a partnership years before the filing of bankruptcy in a fraud case. And even if you accept all these things as true and it weren't a financial fraud case, this still wouldn't be very convincing evidence. You would want to see something like the division of profits between partners, payments, distributions of profits to the partners, things like that. All of this could be true and it could still not be a partnership. It's incredibly unconvincing. Let me go down here. What's the evidence? Chris Kamen, again, he's not a partner and also in prison. This is dated 2007, so almost 15 years before the case. This here is a partnership agreement from 2012. The partners in this agreement are as follows. Thomas V. Girardi, solely 100% the partner. So this is probably the most convincing document because it is an actual partnership agreement rather than something filled out and distributed to a financial institution for money. This is the actual, agreement. That's an incorrect it's. That has nothing to do with anything. It just made me angry. So, there you go. That is a partnership agreement. Says that it is a sole proprietorship. This is 2018. Girardi Keese partnership. Tom Girardi, 100%. Keese, 0%. But that is what the trustee has. That is what they offer. Incredibly unconvincing. And I'm going to show you how unconvincing it is. So there have been a number of cases like the Erika Jayne case that have been brought by the trustee and settled. And I'm going to show you the settlement rates. They should be right here. Here they are. You'll see here we have a $10,000 settlement on a $30,000 complaint. considerably less than half. And again, the attorneys get over 20% of this $10,000. So really, it's going to be under $8,000. We have a 11% recovery, 10%, and 40%, which is, that's a reasonable amount. 47% from a jeweler, 19%, 17%, 3%, 7%, 7%. These are the amounts that the trustee is settling for. She sued for $30,000, got 10, sued for 124, got 14, sued for 102, got 11, sued for 124, got 50, 209, got 100. Scroll down a little bit. Sued for $649,000, got $25,000. 425, got 30. 413, got 30. 1.5 million, almost 1.6 million, got $225,000. And these are what we call in the business, maybe not this one, all of these and this these are fuck off settlement payments. These are, we know you're going to lose. Leave us alone. That is what these are. And accepting these amounts is tantamount to the trustee saying, I know that I'm going to lose this case, so I'm going to take what I can get. And I'm just going to keep scrolling so you can see. I did want to show these two. These are interesting. So casinos are a little bit different. They actually budget for this specific thing. For fraudulent transfer defense, I don't know if they do insurance or not, if it's just a line item expense. I assume it's a line item expense, but they're not going to litigate these things. There are just too many cases. So they settled at roughly 50%, but this is the best that they got. They got 1% from BizJet, sued for $2.8 million, recovered $35,000. $176,000 for 45, sued for $213 for 45, $202,000 for 45. Sued for $50 million, settled for $3 million. 1.3, $35,000, $1 million, $35,000. In total, recovered almost 7%. That is abysmal. And the reason this is particularly problematic is that the trustee has absolutely known about this defect in the bankruptcy estate. There's no question. I mean, she's been litigating in the Abir Cohen or the Axe case since 2021. And I know I have talked to bankruptcy attorneys who have litigated these fraudulent transfer cases. And every single one that I've spoken to has said that they noticed within the first 5 minutes the defect in the formation of the bankruptcy estate. And the reason this is particularly troublesome for me is that this is the third time that the victims of Tom Girardi have been victimized. The first time was, of course, in whatever lawsuit they were the plaintiffs in. The Lion Air defendant or Lion Air plaintiffs are probably the most well known, but there are countless others in all manner, big and small, all kinds of litigation. And so they were victimized the first time. And then their money was stolen from them by Tom Girardi. That is a second victimization. But in my eyes, this is a third victimization. Because what the trustee should have done 4 years ago, when she became aware of this obvious defect in the case, that, again, I'll show you, she admitted to. And where are you? Right here. This, again, in her own words, 100%. It is a sole proprietorship. She's known for years that it's a sole proprietorship. And rather than acknowledge this fact, this defect in the estate, she's just settling for pennies on the dollar. And I know for a fact that that is what is going on here. I don't know if there's anything else I really need to get into here. Oh, wait. The topic of the video, why Erika Jayne should win. Now, some of you may have pieced this together, but let's go back. This is paragraph 2 and 3 of the complaint. You'll see that it is Alyssa Miller. I'm going to delete this so I can emphasize better. Alyssa Miller, who is the Chapter 7 trustee of the bankruptcy case Girardi Keese. Girardi Keese is the debtor in this case, not Thomas Girardi, the person. And this is actually a critical distinction because, as I'm going to show you in just a second, there was actually a dispute between the Chapter 7 trustee for Tom Girardi and Alyssa Miller, the Chapter 7 trustee for Girardi Keese. So there are two separate bankruptcies. You can see right here, the debtor's case, that's Girardi Keese's case, and Tom Girardi's case. So there are two bankruptcies, and the one that should be bringing the complaint against Erika Jayne is Tom Girardi's bankruptcy case, because he is the one who is entitled to file for bankruptcy, Tom Girardi. And the Girardi Keese bankruptcy should have been folded into that bankruptcy case. That's the problem. There never should have been a Girardi Keese bankruptcy. There should have been one bankruptcy case, one set of legal fees, one law firm, one set of attorneys. There should not have been all of these duplicative costs. So again, the attorneys win and the victims lose. But, sorry for that tangent. Again, Alyssa Miller and Girardi Keese should not be suing Erika Jayne. They just don't have the authority to. They don't have any damages because the damages are of the estate of Tom Girardi. Tom Girardi should be the one suing Erika Jayne. There's a whole problem with that with respect to fraudulent transfer actions against one's spouse, but that's a problem for a different day. Oh, there's one more thing I want to quickly show you, which is in this motion for settlement here. You'll see that this was a whole dispute between the different trustees, the Tom Girardi trustee and the Girardi Keese trustee. Each filed a proof of claim in the other's case. So the two trustees, when there should have only been one trustee, were litigating against each other. They couldn't agree on whether some assets, there's one here, I think. Let me see here. It was some property that was purchased by Tom Girardi. I don't know. Sure. There was some property that was purchased by Tom Girardi that was paid for by Girardi Keese. And they were arguing over who owned the property, whether it was Tom Girardi or whether it was Girardi Keese. And they're essentially saying, we can't tell the difference between Girardi Keese and Tom Girardi. And one guy was, Jason Rund, the trustee for Tom Girardi, was saying it belongs to me. And Alyssa Miller, the trustee for Girardi Keese, was saying it belongs to me. And they just didn't put two and two together and realize that in a way they were both right, in a way they were both wrong. It belonged to Tom Girardi, yes, but there should only have been one estate. And that would have simplified matters considerably because you wouldn't have had to litigate that issue. Because there would only be one entity, and that one entity would own the property. So it's just needless expense. And again, the litigation attorneys got 20% of every dollar recovered by the trustee plus 50% of their hourly rate, which I do happen to have ready because I want to show you one thing. So they're getting 50% of these rates. Dan Love was the main litigation attorney. So he would have been getting $3.25 an hour on top of the 20% of any recovery. And I just want to show, there's a paralegal named Karen Files, and I think that is lovely. An instance of nominative determinism, some might argue. But that is the issue here. That is why Erika Jayne should win, is because the plaintiff has no, I don't want to say no standing, because that's probably not right, but they have no grounds upon which to sue because they have no property interests in the underlying assets that they are seeking to recover. That interest would be held by the estate of Tom Girardi because he is a person who can be in bankruptcy as confirmed by Enright Christenberry.